Good afternoon, ladies and gentlemen, distinguished guests. Welcome to this webinar hosted by the Faculty of Law, Nelson Mandela University on COVID and the courts. I'm Avinash Govinji, Dean of the Faculty, and it's a tremendous pleasure to spend this time with you. A special word of welcome to the Judge President of the Eastern Cape High Court, Judge Selby Mbenenge, and other members of the judiciary, representatives from the Legal Practice Council of South Africa, legal practitioners from around the country, fellow academics and colleagues also from other faculties and schools of law in South Africa, law students and members of the community. We are really pleased that so many of you have expressed your interest in this topic and have taken the time to join us today. It is our privilege to have been associated with our speaker, Judge Glenn Goosen, for almost 2 decades. Glenn was appointed as an adjunct professor in the Department of Public Law in 2008, while still practicing as a silk at the Port Elizabeth Bar. As many of you know, he has a particularly strong background in human rights law and advocacy, also previously serving as the director of the investigation unit of the Truth and Reconciliation Commission. He has made a sustained contribution to academic life at our faculty by presenting lectures from time to time and also through his writing in academic publications. Glenn was appointed to the Eastern Cape Bench in 2012, and today's discussion was his brainchild, drawing inspiration from some of the recent developments involving the judiciary across the country. Glenn, thanks for your continued contribution to our society, and we look forward to listening to you. We are indeed proud to be associated with you and eagerly anticipate your period of residence in the faculty when circumstances permit as our first judge in residence. We hope other judges will follow suit and that judges in residence becomes a norm at law schools across the country. This is definitely something to look forward to in the future. Today's discussion will be moderated by Professor Joanna Botha, Associate Professor and Head of the Faculty's Department of Public Law. Joanna is increasingly well known in academic circles for her work in the area of freedom of expression, hate speech and human rights law. I must thank Joanna for always allowing us to tap on her eloquence and for making herself available to moderate today's discussion. Over to you, Jo.
Thank you, Professor Govinji. I'm indeed honoured on behalf of the Faculty of Law at Nelson Mandela University to facilitate this webinar involving Justice Glenn Goosen, whose initiative this was. Today's proceedings will commence with an address of approximately 20 minutes from Justice Goosen, and he will deal with the topic which has been distributed to all of you. We've already received some questions for which we thank you, and Judge Goosen will endeavour to answer these questions during his address. However, there is a Q&A on the right of your screen, and you're all more than welcome to pose questions whilst the judge is speaking. Avinash and I will collate these and then pose questions to the judge after he's spoken. I now hand over to Justice Goosen. Thank you.
Thank you, Joanna. Thank you, Avinash, for that warm introduction. It's always a pleasure to work with you, both of you, and the faculty and with your colleagues. And so I'm delighted to be part of the webinar today. What I wish to do is to focus some attention on the courts and the impact that COVID-19 lockdown has had upon court operations and functions. And I want to do so against the backdrop of our Constitution. I then want to look at court responses to the state of lockdown, both globally and our own court responses. And finally, I wish to end off by highlighting a few lines of development that will need to be explored as we adapt our institutions, particularly the judiciary, to the new realities that confront us. And I hope that these thoughts will stimulate debate and discussion. In the scheme of our constitutional democracy, the courts play a crucial role in the protection of fundamental rights. They also serve to constrain the exercise of power by both the legislature and the executive, and serve to ensure that the state complies with the broad range of constitutional obligations imposed upon it by the Constitution. The state of lockdown in which we find ourselves stands in sharp contrast to the rights and freedoms bestowed by the Constitution. No rights enjoyed by an individual, however, can be exercised in absolute terms. And it is for this simple reason that our Constitution recognizes, in Section 36, that a right conferred by the Bill of Rights may be limited in certain circumstances. and there is a rich jurisprudence developed by our Constitutional Court which defines the principles to be applied in the limitation of rights and the statutes enacted by the legislature. And there is also a rich jurisprudence which deals with the assessment of the lawfulness of executive action. And here the concepts of legality and rationality are central. The outbreak of the pandemic and its arrival on our shores did not occur in a vacuum. It occurred in the context of significant systemic failures in our young democracy, the most obvious being the failure to eradicate poverty and the extraordinary levels of inequality that beset our society. That reality has been brought into very sharp focus by the pandemic and the virtual collapse of the global economy during the period of sustained lockdown, both here and abroad. Corruption is another pre-COVID condition. State institutions charged with the constitutional obligation to promote and protect the rights enshrined in the Constitution, and which have the responsibility to deliver upon the socio-economic rights which are guaranteed to our people, have been hollowed out, rendered almost incapable of functioning in the interests of the public at large. The declaration of a national state of disaster and the regulations that followed had the effect of shutting down all spheres of government and placing the governance of the country in the hands of an executive organ, the National Command Council. This was an extraordinary assumption of centralized power, unprecedented in our democracy. This centralized exercise of control mirrored similar initiatives adopted across the globe. You may recall that not long after our own lockdown was declared and the South African National Defence Force members were deployed to enforce the lockdown, that the Secretary General of the United Nations raised a cautionary warning to regimes across the globe. The warning was that states should be careful to avoid the unnecessary assumption of powers and should take steps to protect citizens against abuses. Most importantly, that upon the pandemic being controlled, there should be a full and complete restoration of the rights abrogated by the lockdown orders. I highlight these issues, let me make this clear, not because I'm of the view that the lockdown strategy was or is inappropriate or perhaps not justified. I raise it because in a constitutional democracy, it is never sufficient that we act with the intention merely to defend our democracy. How we carry out that intention is critical. To ignore the overriding principle of accountability is to place it in peril, and therefore to imperil democracy itself. And let me turn now to how courts, and particularly the South African courts, have responded to the COVID-19 lockdown. I would like to begin by sketching briefly some elements of the global response. Courts in just about every jurisdiction under lockdown have acted with speed to ensure three things. One, the protection of litigants, court officials, members of the public and judges from infection. Two, that litigants and legal practitioners can engage the courts in urgent matters. And three, that existing matters pending before the courts could, by the use of a variety of technologies, be continued, despite the severe constraints imposed by the lockdown. Now, as may be expected, some jurisdictions have responded more robustly and comprehensively than others. What is interesting to note, however, is that prior to COVID-19, calls to modernize the courts, to make greater use of digital technologies and to employ video links or audio links to receive evidence in certain matters is generally not met with great enthusiasm. Getting judges, legal practitioners, and government treasuries to embrace these challenges has been difficult. Arguments about the efficacy of the technologies, access to the hardware, infrastructure, reliability, and security of the technology have usually predominated the debate. So too arguments about whether such systems would work or meet the requirements of procedural fairness. Yet what we've seen over the course of these past months has been the weakness in those arguments. Almost overnight, courts have embraced video conferencing, audio and or telephonic hearings, service and filing of process by email and the like. And all this without major budgets being made available. I wish to highlight a few examples to indicate how some court systems have responded and to point to response strategies which mark the emergence of a new way of administering justice in a time of pandemic. And there is no particular order. On 19 March 2020, the Lord Chief Justice of England and Wales issued the following statement. This pandemic will not be a phenomenon that continues only for a few weeks. At best, it will suppress the normal functioning of society for many months. For that reason, we all need to recognize that we will be using technology to conduct business which, even a month ago, would have been unthinkable. Final hearings and hearings with contested evidence very shortly will inevitably be conducted using technology. Otherwise, there will be no hearings, and access to justice will be a mirage. This was followed by the issuing of a protocol for remote hearings. The protocol emphasized the fact that court proceedings are open to the public, and therefore it provided for participation of court reporters, the publication of hearing details on web-based platforms and websites, and for the live streaming of hearings where this was appropriate. On 27 March 2020, the Supreme Court of Singapore released a guide on video conference hearings using Zoom. The Chief Justice had issued a statement that courts would move to greater use of remote hearing technologies in order to continue to function in the face of lockdown. On 3 April, the Chief Judge in Hong Kong issued a guidance note on remote hearings outlining much the same, namely the use of video conferencing technologies to continue with its functioning. And these initiatives were replicated across Europe, in North and South America. A variety of measures were embraced, with video conferencing and remote hearings being center stage. By early April, courts all across Europe, Central and Western Europe, in England, Wales, Scotland, Ireland, Canada, the United States, South America, including Brazil, Argentina, Colombia, India, Bangladesh, Sri Lanka, Malaysia, Australia, and New Zealand, had all embraced the use of remote hearing technologies to continue to function during the lockdown. And these responses, of course, were not restricted only to those continents. As the crisis enveloped Africa, several African countries, including Kenya, Uganda, and Nigeria, followed suit. And in almost every instance, the policy position expressed by the court leadership was that this adaptation was essential to the continued functioning of courts and to ensure that people across the world had access to justice. And this, in my view, is particularly important for our judiciary. The backdrop of constitutional rights, of openness, of transparency, of democracy and freedom requires that independent courts be accessible and that they function effectively despite the crisis. And that they do so that we can ensure that our societies remain open, transparent, and democratic. Now, how did the South African courts respond to the national disaster? Well, I think it's fair to say that the initial response was largely informed by the extensive measures which were announced by the President, acting in terms of the Disaster Management Act. In essence, the response of the judiciary was to take the courts into lockdown, making provision for access to courts only in relation to matters of urgency and matters concerning the lockdown. In the case of civil and criminal crime trials, these were to be postponed. Insofar as lower court proceedings were concerned, the directives similarly followed the ministerial directions, providing for first appearances in criminal matters, bail proceedings, and for maintenance and family violence-related matters to proceed. We were fortunate that the lockdown came at the end of our High Court term. The result was that it did not have a dramatic effect on the conduct of civil and criminal trials, except for those partly heard matters which would otherwise have proceeded during the recess. Nevertheless, the impact of the general lockdown was such that many matters already enrolled on the court rolls were removed or postponed to a date beyond the initial 21-day period. As with all sectors of the economy, other than designated essential services, legal firms and practices shut down. When the lockdown was extended for a further 2-week period, the Chief Justice issued the directive of 17 April 2020. This directive sought to provide some guidance as to how court functions might be continued. There are 2 important features of this directive. Here, for the first time, the courts opened the possibility of using video conferencing and other electronic means to conduct court proceedings remotely. Although it was framed in discretionary terms and largely confined to applications and appeals, it marked the first serious engagement with the unfolding reality that the global community was focusing upon. Namely, how can we ensure that the courts function despite the stringent and rights-implicating measures enacted to combat the pandemic? The second important feature of the directive of 17 April was the delegation of authority to the heads of court to issue directives applicable to each of those courts. This latter feature may well have been motivated by an understanding that the circumstances faced in each of the divisions differs, and with the intention of empowering the divisions with flexibility. I would suggest, however, that it has also highlighted a weakness in our response to the crisis faced by our courts. One clearly positive effect of the delegation has been the response of the Supreme Court of Appeal. Towards the end of April, shortly before the commencement of the May term of the SCA, President Mandela Meyer solicited input from legal practitioners regarding the operation of the SCA. This was followed by a directive which provided for disposal of certain appeal matters by utilizing Section 19A of the Superior Courts Act, i.e. without oral submissions, and by providing that the court hearings would be conducted remotely. Now, this latter directive, I believe, marked a significant development in the response of the South African judiciary. For the first time in our history, appeal court hearings, consisting of a panel of up to 5 judges, were conducted by video conference, with the judges scattered about the country. We are now at the end of May, and the SCA term is about to end. And not only has it been able to attend to its term role, it has done so with success. And for the foreseeable future, the SCA will conduct its proceedings using remote video conferencing as the standard default position. In the Gauteng divisions and in the Eastern Cape, remote hearings have been employed to ensure that applications and appeals can be dealt with. I understand that with the concomitant availability of the Caseline's digital platform, it was introduced in Gauteng in July last year, significant strides are being made, not only in applications, but that certain trial matters are also able to be heard. In the Eastern Cape, we have looked to a hybrid response, using video conferencing for motion court and appeals wherever possible. In some instances, physical court proceedings have been conducted subject to strict health protocols. Criminal trials are once more being conducted in the division with very strict health protocols. This hybrid response is a function of circumstance and availability of resources. One weakness of the strategy of delegation to divisions is recently highlighted in a submission made by the General Counsel of the Bar to the Chief Justice and to the Minister of Justice. That submission points to inconsistencies between the divisions and a degree of confusion as to what matters can properly be dealt with by the courts. It also points to differences between the directives issued by the Chief Justice and the court directions issued by the Minister. That there are such discrepancies is plain. There is, as the Deputy Minister conceded recently, a difference of understanding of what powers the Minister may exercise and what powers fall within the remit of the Chief Justice. Now, I would suggest that this is a critical issue that we need to confront. It has its roots, perhaps, in what has occurred so far as the development of the self-governance of the judiciary is concerned. This is a project which has been 10 years in the making, and we have still some way to go. But that is a topic perhaps worthy of its own debate. But there is no doubt that the structural and institutional arrangements of the judiciary bear critically upon the judiciary's ability to respond not only with alacrity, but also with purpose and creativity to the circumstances we now face. So what then are we to make of the court's response to COVID-19 thus far? And what should we be looking to do as we go forward? There can be no dispute that COVID-19 will be with us for some considerable time to come. There is some danger that as we move to alert level 3, the notion takes hold that we are by and large returning to normal. After all, we will ramp up our caseloads in the courts, begin to deal with far more physical court hearings, particularly in criminal matters, and we will begin to feel some resistance to the changes that have thus far been introduced. Well, judges and practitioners might say, if we can operate in open court for a trial, why not also for motion court? Why not simply restrict numbers and impose some health protocols? Well, the simple answer is that what lies ahead of us as far as the health impact of this pandemic in South Africa is concerned appears to be the real hump of the crisis. The numbers are already escalating dramatically. And all indications are that if we do not continue to act to combat the spread of the virus, our health systems may be overwhelmed and we will face the consequences of such potential collapse. As the judiciary, I believe, we have a constitutional and institutional obligation to take measures which will achieve two critical things in this crisis. Firstly, to do everything we can to combat the unmitigated spread of COVID-19. And two, to promote measures which will ensure that our courts remain accessible and effective. Rather than regarding the move to alert level 3 as some proximate normality subject to health protocols, we should be taking our responses to date into critical review. We ought to be intensifying our efforts to deliver open and accessible justice. And we ought to be embracing the opportunity to create a judicial system that will not only survive the crisis, but be dramatically transformed in the process. Firstly, the critical review. Have we done enough? Can we do more to create consistency? To the first question, the answer is no, not enough yet to ensure that our courts function fully and effectively. As for the second question, the answer is yes. The judiciary needs to provide clear and effective leadership in this time. It will do so by leading the discussion about how we adapt to this new reality. Court functions are the responsibility of the Office of the Chief Justice. If we are to speak with clarity on the very difficult challenges we face, then it is necessary for the structures of governance to gather, to reflect on our current realities, both locally and globally, and to provide guidance to the country on these challenging issues. Important policy decisions need to be made, and these cannot be left to executive decision-making alone. If there are differences regarding the ambit of executive and judicial authority, then these need to be addressed openly and urgently, lest they paralyze us in our efforts to maintain an effective judiciary. Secondly, open and accessible justice. While our appellate courts may, with relative ease, function on the basis of remote hearings, it is at the level of trial courts that we need to concentrate our efforts. Relatively well-resourced high courts, which also deal with applications and appeals, may very well be able to function using a hybrid of remote and physical hearings. But we need to ensure that wherever remote hearings are conducted, they are open to the public and that they are accessible, notwithstanding the use of technologies. There are relatively simple practical measures that can be taken, such as live streaming on a platform such as YouTube. But we also need to look at creating some virtual court type facilities where litigants appearing in person can access technology to engage the courts. The biggest challenge lies with criminal cases. The main reason is the fact that substantial numbers of accused persons in serious cases are in custody, awaiting trial. Prisons are overcrowded, and there are already significant delays in the processing of these cases. The health risks are obvious, as are the risks associated with physical hearings. We urgently need to put in place systems which will allow the courts to deal with these cases. And here we will need collaboration of a variety of departments, legal professional bodies, and the courts. We will also need funding commitments from the state. If we fail to deal with this, we will be failing in an important constitutional duty to deliver swift and efficient justice for all. The third is to look ahead at a post-COVID judicial system. And thus far, we've used court directives to create a set of rules and directions to facilitate court proceedings. As an emergency intervention, this is understandable. But what the review of global court responses indicates is that the systems which have been able to take their response furthest are those whose legislative or regulatory regimes made provision for hearings before the onset of the crisis. Equally, in those where those legislative and regulatory regimes have been developed as a result of the crisis. Now, I believe that we need to be engaging the Rules Board, even the Law Reform Commission, and the legislature in the urgent development of this regulatory regime. Some jurisdictions have been able to develop legislation rapidly, and others have simply used existing rules. We ought to draw from this global experience. Rule 39.2 of our uniform rules already allows for a court to receive video evidence where it is convenient and expedient. It ought to be no great difficulty to expand the ambit of this rule and to make still further rules to govern court proceedings going forward. I would like to end with a few remarks about the challenges faced by the legal profession. And they are not unique to South Africa. Globally, the economic standstill is having profound impacts on the profession. And these impacts look likely to wreak havoc, particularly to small practitioners or single-person practices. The effects will be felt right across the board. In an op-ed piece published in England looking at the impact that it may have upon the bar, it was suggested that the bar's numbers may shrink by up to 60%. Now, in South Africa, these effects are already being felt. There are some bars which are experiencing severe financial difficulties, and many practitioners equally are in that position. A contraction of the legal profession, of course, will have profound institutional impact, and it will seriously impact the delivery of pupillage and mentorships, as well as positions for candidate attorneys. Now, these are economic consequences which the profession will need to grapple with, but they are not merely sad consequences of the economic fallout. They also impact upon the bench. And that is because there is a symbiotic relationship between the judiciary and the legal profession. An effective, robust, and independent judiciary cannot exist without a robust, vibrant, and independent profession. Courts need lawyers, not just to prosecute cases before them, but as the future of the bench. And all of us, I believe, will need to be looking carefully into the near future and to be working together to adapt to that future. Arundhati Roy published an essay recently reflecting on the COVID-19 pandemic and its impact in India. And she described the pandemic as a portal, as a space to navigate a path from the past to a future. And although her critique was directed at the impact of the lockdown in India, her plea at the end of the article is appropriate to repeat. And I'd like to end with that quotation. She said, "Historically, pandemics have forced humans to break with the past and imagine their world anew. This one is no different. It is a portal, a gateway between one world and the next. We can choose to walk through it, dragging the carcasses of our prejudice and our hatred, our avarice, our data banks and dead ideas, our dead rivers and smoky skies behind us. Or we can walk through lightly, with little baggage, ready to imagine another world and ready to fight for it. Thank you.
Thank you, Judge, for an and incredibly well-balanced speech, which we appreciate very much. We've received a number of questions. I'm going to group these questions. The first group links to resources, an issue which you have addressed throughout your presentation. But we know that courts and legal practitioners need to rely increasingly on technology as a result of the pandemic, both hardware and indeed software. And as raised in the legal brief this morning, there seems to be a problem with the rollout of this type of technology, not only at the higher courts, but also at the lower courts. And so the question is, what are the courts doing to ensure consistent rollout of technology? And what are the obstacles that the courts face as they endeavour to move into this digital space? Does the bench have the will, for example, to engage the government on the issue of new resources and training? And linked to that, what can legal practitioners do to assist, and how should they be adapting to the new status quo? Judge, that's enough questions for now. I'm going to hand over to you.
Yes, thank you. There's no doubt that that there are significant resource constraints, and more particularly at the level of the lower courts, I would think. As far as will is concerned, I think that the leadership of the judiciary has, for some time, been promoting the concept of modernization of the courts, engaging with government in the process of ensuring that we have sufficient budget to be able to acquire the necessary hardware, the software, and the like. So I do believe that there should be no difficulty with that. I think, though, that we should be careful about seeing it in terms of an obstacle. I think that there are ways in which we can apply and use technologies that are already available in order to facilitate the functioning of the courts, at least in the short term, while the acquisition of more modern and more effective hardware and other material is obtained. So I believe that certainly most high courts have access, most judges have access to laptops or desktop computers, and with a little bit of creativity, I would think, we can apply those, we can make use of those, we can establish remote stations, for example, where motion court could be heard, where laptops can be shared between judges if they have no access to them. And perhaps these sort of measures can equally be applied at the low court. But it is a constraint that we must accept. But I don't believe that that we should view it simply as the constraint and wait for the rollout to take place. I think we're charged with the responsibility to push ahead as hard and as fast as we can.
Yes, thank you. The second group of questions, Judge, links to security issues and also the question of the integrity of court proceedings. So on security issues, questions are being posed about how do we deal with security hacks? How do we deal with issues relating to fraudulent documents, for example, being emailed? In addition to that, what is the impact then going to be on court proceedings? Will the rules of evidence need to change, for example? How do we deal with cross-examination if one, for example, cannot see a particular witness? And I see from the live Q&A questions that these are very much the types of questions that our participants are asking. Has any thought been put into how we deal with these particular, I'm not going to call them obstacles, but challenges? I'm going to hand over to you to deal with those. Thank you, Judge.
Thank you, Joanna. Yes, look, security, of course, is an obvious concern. You know, making use of the Zoom platform in order to conduct a hearing, or Microsoft Teams, as we are conducting this webinar, does mean that there is risk of security breaches, people who ought not to be in coming in, or once they're in, engaging in unacceptable behavior. So yes, those risks are there. But by and large, I think that we need to understand that what we're doing in the conduct of court proceedings via using remote technology is that we're conducting a court. Those courts are open, and they should be open and accessible. So, apart from inappropriate behavior or the like, which could cause embarrassment, the access to the interface that is used for the conduct of courts, I'm not sure that one necessarily sees that as a major concern. Questions, of course, around the integrity of documentation and so on, those are slightly different questions. We know, for example, in Gauteng, as part of the court online system that the Office of the Chief Justice has been putting in place, that a system of e-filing has been introduced. Parties can upload all of their documents, and those then are available to the judges and to other parties who are participating. And in those platforms, security mechanisms are built in. And so they're not, I don't think again there that's necessarily a difficulty. One always has these sorts of difficulties, but I don't believe that they would necessarily preclude the use of or the robust use of these technologies. They're things to bear in mind, and our rules ultimately need to take cognizance of those difficulties. As far as cross-examination, the question of if you're going to use that generally relates to the use of these sort of technologies for trials. Thus far, as far as the directives are concerned, the process is not limited to, but it is primarily directed at application proceedings. But there are several jurisdictions, the United Kingdom, Australia, for example, many of the states in the United States, in Canada, and numerous other jurisdictions where full-blown trials are being conducted using remote technology. And yes, there are always questions around procedural fairness, whether a party has the advantage which they would otherwise enjoy in a physical hearing when cross-examining a witness. But I'm not sure that those are real or substantial impediments to the conduct of such virtual trials. There are two points to be made here. One is a reported case which came out during the course of April. I think it was published on the 6th of April in the United Kingdom, where it's a joint liquidator. I think it's called One Brighton Place, and then there is a similar one in the Federal Court of Australia, Capich vs Ford Motor Company. These were trial proceedings that were pending, and one of the parties brought an adjournment application saying they were not going to be able to deal with the matter appropriately and so on. And the judgments were that the trial adjournment was refused. In both instances, the courts dealt with the arguments relating to procedural fairness and looked at the overarching interests of justice that would be served by ensuring that those matters do proceed. So I think that's something that we need to look positively to. Thank you. Over to you.
Thank you, Judge. We have a number of legal practitioners online, attorneys, advocates, and indeed students in their final year who are worried about the impact of the pandemic and the opening of the courts on their practices. And indeed for LLB students, possibility of getting articles or pupillage. Have you any insights on a relationship between legal practitioners, the judiciary, academics, on how we move forward to address what is undoubtedly a problem that worries all of us? I'm going to hand to you.
Thank you, Joanna. I've not had any direct discussions with practitioners on this issue. I'm aware of the fact that, as I mentioned in the presentation, that there are some bar councils, because their members are struggling with income, that they themselves are placed in severe financial straits. And that, of course, is going to have a major impact. And equally with firms of attorneys, retrenching staff, perhaps not making candidate attorney positions available. So the general economic fallout will have a significant effect on legal practice. And I think that it's why I mentioned that I think that the Legal Practice Council and the bar councils need to be looking very carefully at those issues. We need to mitigate that impact as far as possible. I think the truth of the matter, though, ultimately, is that legal work will continue. I mean, even if the economy contracts significantly because of the lockdown, there will continue to be a need for legal practitioners. And if the courts are functioning and open and ultimately functioning fully, well then there should be available opportunities for young practitioners to come through. The biggest challenge, I think, will be to begin to adapt to new ways of practice, new ways of engaging with dispute resolution, for example, not only through the courts, but through mediation and through arbitrations and the like. So there are I think, a range of different opportunities that will present themselves through this crisis, and we need to be looking for those opportunities so that we adapt positively. Back to you.
Yes. Yes, thank you, Judge. It was a question that I was going to engage you on because one of the questions that we received before this, and some questions have been posed whilst you were speaking, and that is if courts are, and indeed practitioners are, unable to adapt, I hesitate to call it the new normal, but let's call it that, and unable to serve their communities, is it not possible that courts will lose business, so to speak, to ADR practitioners, and that mediation will be used more and more extensively? And what impact would that have on our justice system? Thank you.
Yes, thank you. I'm not sure that there'd be a difficulty with the losing of business. I think courts are fairly fairly overstretched to deal with the caseload that besets them presently. What is interesting, though, is I think it was on the 9th of March, Rule 41A, which was a new rule inserted in the uniform rules, came into effect, and that rule basically requires the parties at a very early stage, either at the stage of issue of summons or at the stage of filing a notice of intention to defend, to set out in a notice what their attitude is to the submission of the matter to mediation. And whilst there may be some debate about the way in which it's formulated, what it will require, and this is unrelated to the lockdown, is that parties give very serious consideration to mediation as an alternative alternative form of dispute resolution. In the disaster management regulations, those regulations contain a provision which seeks to encourage mediation and or arbitration in claims against the state. It's formulated in terms which don't seem to restrict it to COVID-19 related matters or matters related to the Disaster Management Act. Whether that is properly introduced in the regulations, of course, that's another debate potentially. But what it does signal is that there is a desire to engage in the range of alternative dispute resolution mechanisms. I prefer not to use the term alternative. I prefer to use the term appropriate. So, parties need to consider this. I don't believe it's something that will detract from the judicial system at all. I believe it will enhance it. Back to you.
Thank you. Yes, I see we're receiving some messages from an advocate, Leon van Gaas, who tells us that the Inns of Court in the UK have published a document entitled Principles of Remote Advocacy, which may be useful. But he's also suggesting that it might be useful for the bench and the bar to engage and to draw a directive to deal with the practical implications of virtual hearings. And I wonder if you have any comments on that, Judge Glenn.
Thank you. Yes, I'm aware of that, of the document. In fact, the International Advocacy Training Committee, which is responsible to which the General Counsel of the Bar is affiliated and conducts most of its advocacy training under the auspices of the IATC, recently had a webinar looking at sort of practical advocacy skills that may need to be developed for remote hearings. So yes, the Inns of Court in the UK have published that guideline. As I indicated in the presentation, there is a protocol that has been published in the United Kingdom, which outlines an approach to virtual court hearings and seeks to guide both judicial officers and, of course, the practitioners in those hearings. I believe that there would be a great deal of benefit to engage with practitioners, with the bench, and other interested parties in the development of these sorts of protocols, so that as we begin to use them more frequently, we do so in accordance with best practice that is currently being developed globally. Back to you.
Yes, thank you, Judge. Of course, the reality is that even for motion court proceedings, some respondents and indeed applicants will need to appear physically and to be present in court due to our ever-prevalent socio-economic circumstances. How would we deal with that going forward, even at possibly level 3 or level 2? What are the courts doing to ensure the protection not only of legal practitioners, but also parties themselves from the impact of the virus? Thank you, Judge.
Thank you. Well, what we've done in the motion court proceedings that have been conducted in the Eastern Cape, there've been 1 or 2 instances where a litigant arrives in person at the court. So rather than firstly conduct the court from chambers, what we've done is to conduct the court remotely, but from inside the court itself. The registrar's staff and the security, for example, have been alerted to that fact. And so if any person arrives at the court building and therefore a matter that's on the roll, they could be brought through to the court. And it's possible then, even while the remote hearing is being conducted, to engage with that litigant to establish how to deal with the matter. But I think that going forward, there are a range of different ways in which this can be done. Making provision, for example, for what one could call a remote hearing centre would be one way to deal with that. It wouldn't require a great deal of infrastructure. Setting up an office where there is a computer, for example, which is linked to the court, where the private litigant could, with safety, be brought into that facility and could then link with the court. So these are possibilities that one could employ. So I don't believe that it is too difficult to deal with the practicality of those situations. But what we do need to make sure of is that when a remote hearing is going to take place, it needs to be published. So members of the public need to know that that hearing is going to take place. I would think ideally they should be able to log on, as someone might log on to a webinar, for example, to observe it. Certainly members of the press who ordinarily report on matters must be informed and must similarly be invited into the hearing, so that the hearing as a virtual hearing meets all of the requirements of an open and public court sitting. Thank you.
Yes, thank you, Judge. And indeed, the need to ensure that we protect the rule of law will remain ever prevalent. And we thank both you and indeed the JP and all our legal practitioners, those who have tuned into this webinar and those who may tune into future webinars and who are interested in protecting our justice system, for the efforts that you've made to promote justice in this country. And undoubtedly with judges such as yourself and the JP at the helm of our Eastern Cape High Court, we're very grateful for the work that you are doing, and we trust that this will get better and better and improve, not only with your input, but also with our input and the input of our legal practitioners through webinars such as this. So we at the end just about of our 1 hour, and we thank everybody who has tuned in today. We especially thank you for the efforts that you've gone to make this webinar a success and to give us your time. Also thank the Dean of the Faculty of Law, Professor Governji, for hosting this webinar, our ICT department, and to everybody who has made the time to be with us today. So thank you, Judge, and we look forward to more engagements of this nature, and also from or to the participants, if they could also make suggestions going forward as to issues that they would like us to raise and to deal with. So thank you, have a good afternoon. Goodbye, everybody. Over and out. Thanks.
Thanks.